Attorney first.
As District Attorney Urmanski concedes that the intervener plaintiff, as you just heard, have standing, all plaintiffs should be able to proceed, and that's the easiest way for this court to address standing. This court need not consider our standing further because District Attorney Urmanski concedes that the interveners do. District Attorney Urmanski's attempt to argue otherwise fails for two reasons. First, the argument that you just heard about the general rule that the case should not be able to proceed or based solely on the intervener's argument is based on a separate Chapter 227 case where essentially there were 227 petitioners who were untimely, who then tried to disguise themselves as interveners. That's an entirely separate process than what is here today. And second, the federal case law to which District Attorney Urmanski points to argue that somehow our disuse claim specifically should not be able to proceed because that's separate, that's not a claim that the interveners are raising, misunderstands the federal law he cites. The federal law that he cites comes from a Supreme Court case called Chester, and there the court emphasized that there should be at least one plaintiff with standing as to each form of relief. There is no form of relief that we seek that the interveners do not also seek. But moreover, unlike in federal court, standing, of course, in Wisconsin is not a matter of jurisdiction, but rather is a matter of sound judicial policy aimed at ensuring full and efficient litigation of the question before the court.
I just want to, so if I were to conclude that the plaintiffs do not have standing and the interveners do, is your position that you would have the rights of an ordinary plaintiff?
That, just to make sure I understand the question, if the court were to conclude...
Filing things and as if you had not been dismissed from the case?
So the Attorney General would have a statutory right to be involved, if I'm understanding Your Honor's question, and that's under 80604 sub 11, if that is Your Honor's question. So, but even if this court wished to consider standing further, the state plaintiffs absolutely have standing. The state plaintiffs have mandatory statutory duties, not discretionary, mandatory duties that require them to know what is and is not criminal law on abortion in the state of Wisconsin. As to Attorney General Call first, Attorney General Call, as part of his broader duties to the Wisconsin public, as the state's chief criminal law enforcement officer and litigator, has duties that require him to train law enforcement, to advise district attorneys, and to represent the state in criminal appeals. To do all of this, he has to know what is and is not enforceable Wisconsin criminal law. And indeed,
would those, agencies and officers that you refer to the Attorney General advising, would those agencies and officers have standing to seek that same advice from this court?
So I think that the enforcers of the particular statutes at issue, I think, are indeed proper parties to a declaratory judgment action. And I would say that that directly contradicts District Attorney Urmanski's point that they are not properly involved in the case. It is black letter Wisconsin law that the state officers who could enforce the law at issue are proper parties, including proper defendants, to a declaratory judgment action concerning the enforceability of the law, and that's from cases like Kochke v. Evers. And indeed, the Wisconsin Supreme Court has recognized that a declaratory judgment action where the question of enforceability of Wisconsin law presents a question of vital importance to the entire public, where the question, if left unanswered, will leave uncertainty and doubt in the minds of innumerable citizens of the Wisconsin public that that's the precise scenario where it not only is proper, but where it makes complete sense that the Attorney General brings a declaratory judgment action. And indeed, it is hard to fathom, certainly in modern Wisconsin history, a circumstance where those concerns are more pressing than they are here. And turning to the Medical Examining Board, with the investigatory help of the Department of Safety and Professional Services, must, not may, must, statute says shall, investigate allegations of unprofessional conduct, which includes any violation, not a conviction for, not just a conviction for, any violation of a law of the state of Wisconsin related to the practice of medicine. And if the court looks at 44802 sub 3, which sets out this authority and required duty of the Medical Examining Board, what the court will see is that there are statutes cross-referenced in that statute that require other entities to report alleged unprofessional conduct to the Medical Examining Board.
But isn't it, I think you would have to agree that the state of Wisconsin doesn't have the authority to punish someone based on alleged violations. Due process requires more than allegation, correct?
Correct, Your Honor, but the Medical Examining Board's duty is to investigate. It has to investigate. And so the Medical Examining Board is not a court in the sense of being able to define what is and is not.
So then these plaintiffs would have to collect evidence, consider the alleged crimes. How do the medical professional plaintiffs, how do they know what they're looking for?
Well, I think that's really the problem, is if the Medical Examining Board does not know whether or not the mid-1800s near total abortion ban is Wisconsin law, or whether Wisconsin's many modern statute.
Aren't they guided by the interpretation, or like someone else's interpretation of the criminal statutes?
No, at this point, they are not serving in a quasi-judicial role. They need to be able to know what the law actually is. And right now, there are two sets of laws that directly conflict. And so they aren't able to perform those functions, their required duties, without that clarity.
So if the law were clear, would they then track all 72 district attorneys' charging policies?
So their job as the Medical Examining Board is to investigate allegations of unprofessional conduct that come to them. And so their job would be when those allegations are...
You're basing that on a criminal statute. That unprofessional conduct we're talking about in this instance would be a crime, correct?
It would be a violation of any Wisconsin law related to the practice of medicine.
So why can't they rely on local prosecutors to make that determination?
Well, because ultimately, there can only be one answer to whether or not this statute, the mid-1800s abortion ban, is or is not the law of the state of Wisconsin. That's not a matter of prosecutorial discretion. No prosecutor in the state of Wisconsin has authority or the discretion to prosecute something that is not actually the law of the state.
If it were determined to be a crime, but perhaps DA Chisholm or Ozanne didn't enforce it, but perhaps DA Armansky did, so how then are these plaintiffs harmed by the inconsistent enforcement of the statute?
So it's not the referral, essentially, that would come into the Medical Examining Board isn't just referrals coming, wouldn't just be referrals coming from district attorneys. When you look at the entities cross-referenced in 44802 sub 3, what you'll see it's hospitals, it's insurers. And so if there is an allegation made to the board that there has been a violation of the law, then the Medical Examining Board has a duty to investigate that violation. And so I think that's where it's important to note that this is not a duty just as to convictions for a violation of the state law. It's also for those alleged violations. And Armansky has no answer to the mandatory nature of these duties for the state plaintiffs, and that alone shows why his motion to dismiss on standing should be denied. And just lastly, on as to the argument that this is an advisory opinion, the state of Wisconsin and women in the state of Wisconsin are not currently able to receive critical health care that they have had a constitutional right to receive for nearly half a century because of the very lack of clarity in the law that is at issue and that we're seeking to resolve. So this is the exact opposite of an advisory opinion. I would stop there.
Okay. Any response?
Briefly, Your Honor, I guess to the last point made, the law is well established that you cannot rely on the standing of third parties to bring a judicial action. District Attorney Urmanski has acknowledged in his briefs that proper physicians, for example, could have standing to bring this case. We have not challenged the standing of the interveners at this stage in the proceedings. So I think that would be the response to that. With respect to some of the other points made, the Attorney General's office is correct that FOX is a case dealing with standing and interveners in the 227 context, but the law on which it relies was not 227 law. It was not agency law at the federal level. It recognized that Wisconsin statutes relating to intervention are essentially the same as the federal rules of civil procedure, and it relied on federal cases addressing those. Another point made was you only have to have standing to seek a particular form of relief as to a particular claim. The Fourth Circuit says particular claim on one of the cases we cited. But beyond that, I think throughout the argument there, I heard very little about District Attorney Urmanski or the other district attorneys and how the other district attorneys' opinions would have any impact at all on the state plaintiffs. This is precisely the state ex rel. La Follette versus Damon situation, where you have a state officer who has a duty. The governor had a duty to make nominations to these particular vacancies in that case. You have another state officer, in that case the Secretary of State, that says, I'm not going to recognize the people that you are appointing to those positions. The governor comes to court, and the court says, you don't have standing. You have your duties. The Secretary of State has his duties. And his opinions don't impact your ability to perform your duties. The Attorney General has mandatory duties, one of which is to issue opinions as to the law when requested by others. I mean, is this going to turn into a situation where the Attorney General receives an opinion request on a law that is tough and turns to the court because the Attorney General doesn't know what the law is? I think really we should look at the actual impact that District Attorney Urmanski's or any of the other district attorneys, their opinions have on the plaintiffs, and there is none.
May I briefly respond? So first of all, Koschke v. Evers in those cases established that it is black letter law in Wisconsin that proper defendants to a declaratory judgment action concerning the enforceability of a law are the state officers who could enforce that law. And here that is the offices of the district attorneys in the 3 counties where abortion services were being provided. Second, as to the Dahman case, the critical distinction with that case is that there, the governor, the court stressed that the governor could and had no restraint on being able to make the appointments through which that were at issue in the declaratory judgment action that he sought. And so the court said, well, look, it makes no difference if we say or answer this question now, nothing will change. And that's the exact opposite of the circumstances here, where our declaratory judgment act at its very base purpose is to be liberally construed to provide clarity in the advance of the threat of a prosecution for the reason of providing clarity. And as to the Attorney General's ability to offer opinions, again, I would stress that we are here today on District Attorney Urmanski's motion to dismiss. He cannot show that it is improper for the Attorney General to have standing in a declaratory judgment action like this when the Wisconsin Supreme Court has recognized that this sort of extraordinary conflict in criminal law is the very scenario where it is not only proper but makes complete sense that the Attorney General would seek to obtain clarity for the state in court through a declaratory judgment. Thank you.
Thank you. I just want to briefly, I guess it's come up a little bit, but touch on the other district attorneys as defendants. And is it your position that their interests are adverse, as you know, to be justiciable? There has to be a controversy between persons whose interests are adverse. The amended complaint alleges that the interests of the plaintiffs may become adverse to DAs Chisholm and Ozanne because, and I quote, regardless of whether these DAs intend to enforce the section 940.04 as applied to abortion, a successor in his office may intend to. I think we can agree that all government offices are subject to the general proposition that a successor may choose different policies, correct?
Yes.
And so if we assume for purposes of the motion to dismiss that the amended complaint alleges a justiciable controversy against DAs Chisholm and Ozanne, could they in essence file a short affidavit saying that they agree with the policies put forth by the plaintiffs here in regards to the interpretation of 940.04 and then be entitled to summary judgment?
So what's critical there is that we bring this suit against their offices in their official capacity. And so that's the distinction, that it's not the position of the particular holders of that office, but rather the office itself. And I think what's really important to the point that Your Honor mentioned about a successor in office is that what we're talking about here is the enforceability of a mid-1800s ban that in the statute says it's listed as a felony, and the statute of limitations on felonies in the state of Wisconsin is 6 years. And so whether or not these particular, the holders of these offices at this point would seek to enforce the law if it were enforceable, the fact remains that those offices are proper defendants because they could be enforcers. But the last point I would make on that is, again, that we are here today only on District Attorney Urmansky's motion to dismiss. The other two defendants in the case have not so moved. And so we think that it would make sense, assuming the court were to deny the motion to dismiss, what we would then intend to do would be to seek judgment on the pleadings as to our first claim, which would then give all of the parties an opportunity to be heard because, as the court noted, the other two defendants have not moved at this point.
Anything further on that matter from any of the defendants?
I'll let the other district attorneys speak for themselves, but I did have one point on that, which is to the extent the other district attorneys have said they're not going to enforce the law, this is actually almost the right application of the Poe versus Ullman case that the Attorney General cites for the desuetude doctrine, which is that case didn't recognize the doctrine of desuetude as the Attorney General's office has suggested. It said there's actually no standing or justiciable controversy where there's really no likelihood of the enforcement of the law. And I guess if the Milwaukee County District Attorney and the Dane County District Attorney are saying they're not going to enforce the law, I would fail to see how there's a justiciable controversy with respect to those district attorneys, but I'll turn it over to them on this.
Yeah. Thank you, Your Honor. We had submitted to the court a letter of April 26, just outlining briefly with 4 points our position on it, so the court would be alerted to that.
I have received it and read it, so thank you.
Thank you, Your Honor.
Can you use my phone, please?
Sorry. The briefing has been extensive, and we felt that enough briefing, a letter would be sufficient for our purposes. The issue that we raised initially in that letter was prosecutorial discretion. We don't know how the court is going to rule on the substance of this case. If the court were to rule that this statute or any related statute is a valid statute, the Attorney General does not have the authority to invade or encroach into prosecutorial discretion. In fact, the statutes in Wisconsin are very clear that prosecutorial discretion, the decision for filing an information or prosecuting a felony case in Wisconsin is exclusively up to the district attorney's office. It is not the role of the Attorney General to involve itself in those prosecutorial decisions. And if I recall correctly, all three defendants raised that issue in their pleadings in this case. Nonetheless, you have to have a valid law. And the idea that an 1849 law would be utilized in 2023 with all of the advancements in medical science, all of the rights that had existed amongst Wisconsin women for 5 decades, seems to be inconsistent with the laws of Wisconsin and seems to be inconsistent with the fundamental fairness and need to pursue justice that all of these district attorneys are imbued with. So we felt, as we put in the letter, that the standing issue, and we have great regard for Attorney General Call and his office, but that the standing issue, because their contentions flirted with this intrusion into prosecutorial misconduct, or prosecutorial discretion, that the standing was questioned, and we did question that. The issue of the standing of Sheldon Wasserman is somewhat a closer issue. His office has an obligation under Wisconsin Administrative Code Med 10 to regulate physicians, and the interveners clearly have standing, as do physicians throughout the state. And it's not just obstetricians; it's emergency doctors and family practice. It's vast. Under Med 10, the standard is whether or not there's been unprofessional conduct. Your Honor was talking about criminal violations. The criminal violations, such as, let's say, driving under the influence, may or may not implicate discipline under Med 10. That's amongst their discretion as to how they deal with that. But it's a closer issue regarding DSPS and their standing on the case. One of the pivot points in that, the Attorney General is generally charged with defending district attorneys. District attorneys are not infrequently defendants in actions, and it's the Attorney General's office that defend them in that regard. That is not the case with the DSPS or Dr. Wasserman. Their role is clearly something different and very much germane to the substantive issue in the case. So that was a little closer call in our opinion. And that's as much as I would weigh in on that issue, Your Honor.
Thank you. Attorney Poling?
Your Honor, very briefly, District Attorney Ozan would agree with what Mr. Lieb just said with respect to prosecutorial discretion. DA Ozan has set forth that and other affirmative defenses in the answer, and we have not participated in the briefing on the motion to dismiss, so we will save any other positions that we have for what time would be appropriate in the case.
Great, thank you. So shifting away from justiciability, I guess this is my question for all of the parties. I will turn to you first, Attorney Freehill, because I think your client spent the most time addressing this in the brief, but I'd like to spend a chunk of time on State v. Black. My general question, and I'm going to break it down, doesn't this really resolve the issue? as the parties know, the Wisconsin Supreme Court analyzed a different subsection of 940.04 to the one at issue here. The Black court looked at subsection 2 of 940.04 and determined, and I quote, "The words of the statute could hardly be clearer. The statute plainly prescribes feticide." The text analyzed in the Black decision, and I quote, "Any person other than the mother who does either of the following is guilty of a Class E felony." And sub A, intentionally destroys the life of an unborn quick child. And so that is section 940.04 sub 2. So if I replace the phrase, "does either of the following," with the prohibited act that follows, I end up with "any person other than the mother who intentionally destroys the life of an unborn quick child is guilty of a Class E felony." And again, the Wisconsin Supreme Court has said that it could hardly be clearer. So if I compare that to 940.04 sub 1, the statute at issue here, I would be repeating myself. There's only two differences. I believe the use of the word quick and the classification of the felony. So here are my questions, or starting question, I suppose. Does the circuit court have the authority to overrule, modify, or withdraw the language from a binding Supreme Court decision? Attorney Freehill, I'll start with you.
So I want to be sure that I understand the question. So the language you're talking about removing, or whether or not you have the authority to remove, is what?
It's a really general.
Okay.
It's a, probably has a little more snarky intention than I do, but sort of to me, the Supreme Court has said this almost exact language prescribes feticide. It is not about consensual abortion. And I realize, Defendant Hermansky referenced that, well, they said this only applied to subsection 2, but the language is almost identical. So I don't know, that seems
yes, Your Honor.
well settled to me.
I'm with you, Your Honor. It's certainly, the opinion makes clear that it is not discussing sub 1, right? Because this defendant committed feticide something like 5 days before the baby was due. So it was clear it was a quick child. There was no question there. So the court couldn't consider sub 1 because the defendant was not being charged under that crime. This was a criminal case.
Right.
And so it is our position that exactly that sub 1 is just as clear. There's no different logic that would apply to that language, which is almost identical, and as you identified, has hardly any difference there. That sub 1 is also, if anything, a feticide statute. The court in State v. Black made clear that the title abortion doesn't mean anything, and that this clearly describes the instance of a non-consensual destruction of a fetus before it is born. So that it's our position that's, even though the Wisconsin Supreme Court did not in that ruling rule on sub 1 because it couldn't, that exact same logic applies to what 940.04 sub 1 is. It's a feticide statute as well.
And is it your position that State v. Black is still binding precedent on interpretation of subsection 2?
Yes, it is. There hasn't been any further word on subsection 2.
And, does the difference of the word quick in either one of them change the analysis?
Well, certainly, as we argued in our brief extensively, the word quick essentially has no meaning at all, particularly in the setting of a medical consensual abortion, right? It's not a medical term. It's not actually clear. Colloquially, in the past, that was a term used for when the fetus moves. somewhere around 4 or 5 months. Well, a pregnancy is only 9 months long, so 2 of the 9 months is a pretty large amount of time that there's a gray area of when a fetus is quick or not. But it certainly, there's nothing about in this medical scenario which we're talking about today, in which, does it mean it's actually felt moving? It's capable of moving. Subjectively, the mother should have felt movement. It's a vague term. So certainly we feel it has no place in the modern, it's not used in the 20th century abortion laws, of which Wisconsin has passed many. It's not used in the 21st century abortion laws, of which Wisconsin has passed many. And so it certainly has no place in the medical context we're here for today.
And Attorney Tom, I will turn to you on that.
Thank you, Your Honor. I guess to respond to the last point about the use of the term quake, this law was passed in 1955. So the suggestion that that term has not been used in a 20th century law is not true. But beyond that, looking at State versus Black, I think we need to start with the context of State versus Black and footnote 2. State versus Black was an attempt to apply this statute in the case of feticide. And in footnote 2, our Supreme Court says, as Your Honor recognized, they expressly state we're only dealing with 940-02A.
Because it wasn't before then.
Correct. And then they say, additionally, we do not agree that 940-042A was to apply only to consensual abortions. The plain language of the statute evinces an intent otherwise. And then if you turn to the actual body of the brief, what they say is, any attempt to apply 940-042A to a physician performing a consensual abortion prior to viability would be unconstitutional under Roe v. Wade, and then any attempt to apply it to a physician performing a consensual abortion after viability would be inconsistent with the newer 940-15, which limits such action and establishes penalties for it. And we've said that's dicta, it's not binding, is dicta really, in Wisconsin, my understanding is calling something dicta isn't really recognized so much as what we, in Wisconsin. And I guess my response to that would be, is, Your Honor, the court feels it's bound by that particular language. The court is quite clearly saying there is no conflict with 940-15 post-viability, and that the application of 940-04 pre-viability is prevented only by Roe v. Wade.
But the court is also very clearly saying that it could hardly be clearer what the language means, right? Just those words in the quote, it could hardly be clearer. Aren't they also saying that? And that's certainly not dicta in this case.
I believe what they are saying is it could hardly be clearer that this statute encompasses both consensual abortions and feticide. Again, the factual context of the case matters. There was somebody that was charged with feticide saying, this doesn't apply to me. This applies only to consensual abortions. They're saying, no, it could hardly be clearer, and that's footnote 2. It is not limited only to consensual abortions. But I'd like to make a couple of additional points on this. First, to the extent the court feels it's bound by Supreme Court precedent, we have multiple Supreme Court cases applying 940-041 in the context of consensual abortions. Those cases have not been overruled. 2, this case was decided before Kalal, which is sort of the current, I would say, standard for statutory analysis in the state.
But this case was also decided, some 40 years after the cases you're referring to also, correct?
That is correct, but this court says nothing about overturning those cases. This court expressly confines its holding to 940-042. If you have Supreme Court precedent applying 940-041 in the context of a consensual abortion, and you've got a footnote from this court saying, what we're saying is this isn't confined only to consensual abortions, I don't think this court is bound by State versus Black in that respect. I think
based on the footnote.
But based on the footnote and based on the fact that we have Supreme Court cases applying 940-041 in the context of consensual abortions. And I'd like to make a last point, and this isn't in the briefs, and I intend to submit a letter on it, which is after State versus Black, our legislature passed a feticide statute. It's 1997, Wisconsin Act 295. And as part of that statute that put protections for unborn children in homicide statutes and things like that. But it also passed Wisconsin Statute 939.75. And in Wisconsin Statute 939.75 is language that essentially says all of the various homicide statutes and other statutes where unborn child protections were put in by the legislature do not apply to any of the following. An act committed during an induced abortion. This subdivision does not limit the applicability of subsections 940.04, 940.13, 940.15, and 940.16 to an induced abortion. And this is our legislature speaking after State versus Black. So I think there's probably an argument to be made that the legislature has spoken on this issue after State versus Black and has said, actually, 940.04 is an abortion statute. But again, as I indicated, I think footnote 2 says it is an abortion statute. It's just also a feticide statute.
Thank you. I will go.
Your Honor, could I just respond briefly? First, the cases that DA Urmanski is referencing have the enforcement cases of 940.04. All of them are before State v. Black. There is nothing else in Wisconsin besides State v. Black that considers 940.04 in the context of the more modern laws, 940.15, 253.10, 253.105, everything that followed. So to say that, well, we have all of these enforcement cases of 940.04, sure, we do from the far past, but we have nothing that tells us what happens today when that law is being considered in the context of the something like 16 or more other laws that do regulate abortion. And then on the second point about the feticide statute, the more recent feticide statute, if I'm hearing Attorney Tome correctly, it says there's no effect on the applicability, there's maybe a drafter's footnote or something about the applicability of that to abortion, but it doesn't say what that prior law, what 940.04.1, how that does apply to abortion, if at all. So I think that to say that, well, there's some sort of note in a more modern law saying it's not meant to affect 940.04.1, well, what is the effect of 940.04.1? And that question hasn't been answered. And that legislative footnote does not answer it either.
Attorney Jurist, I want to certainly give you an opportunity to weigh in this, as well.
Thank you, Your Honor. So, Your Honor is correct that the language of Black, all of the rationale of Black in terms of the text, analysis of the text, in terms of the arguments about legislative history, all of that equally applies and is equally true here. And so I think everything that District Attorney Urmanski is saying about the text of 940.04, about its legislative history, that's all been addressed by the state Supreme Court in Black, and there's no basis, and I don't think he identifies that through the footnote, to say otherwise, particularly where the state Supreme Court, and of course no court in Wisconsin can dismiss anything the Wisconsin Supreme Court says as dicta. The state Supreme Court held that 940.04 and 940.15 cannot both be applied to abortion because of the conflict that would happen. And so 940.04, based on the text alone, is a feticide statute. And just as to the point about the earlier prosecutions under 940.04 as to abortion, one of the cases that we reference, and this is footnote 12 of our brief, one of the very, very rare historical prosecutions was indeed under 940.04 sub 2, i.e. what was at issue at Black, and that's the Harling case that's in the footnote. So I don't think that does any work for District Attorney Urmanski. And in terms of the idea of the legislature after Black passing a feticide statute, the District Attorney Urmanski otherwise argues, though he's mistaken when he argues it in the context of the conflicts between the abortion statutes if 940.04 applies to abortion, but he points out that criminal statutes can overlap, that there can be criminal statutes where the same act is a crime under more than one statute. That happens all the time in the criminal law. That's entirely fine. Where it becomes a problem is when the criminal law says two directly opposite things about what is and is not legal. And so insofar as his point is to try to say that because there is another feticide statute, that somehow means that the rationale of Black wouldn't apply, just I think misunderstands the function of criminal law. And notably, even when the legislature passed those laws, it didn't change the text of 940-04. And so I think that's really the key point. That's the rationale of Black.
Attorney Tone.
Yeah, just briefly, I think the subsequent laws, to the extent they're relevant, I think evidence the legislative understanding that 940-04 still applies to abortions. I think, you know, when the Supreme Court cabins a decision as it did in State versus Black, I don't think a circuit court can lightly disregard other Supreme Court decisions applying a different section that is not at issue, that has been expressly excluded from the decision in State versus Black to abortion. I think under these circumstances, it would be our position that if the question is, does 940-04-1 apply to abortion? We have Wisconsin Supreme Court cases applying it to abortion. The case that applies a separate subsection to a feticide says we're only dealing with this specific subsection. I think in that circumstance, you have to say this can apply to abortion.
So assuming, I guess, you know, if either if or if it does not control, if Black does control attorney jurist, is there any implied repeal?
So I think there are alternative theories in the sense that if 940-04 sub 1 is a feticide statute and cannot be applied to physicians providing consensual abortions in the state of Wisconsin, then there's not a conflict between 940-04 sub 1 and Wisconsin's many statutes regulating the provision of lawful abortion. But if the court concludes that it is an abortion statute, then we get to implied repeal, and then there is absolutely a conflict. And so if I may go into our implied repeal arguments.
Sure, yes, and I'm curious, I know it's in your briefing, but as far as your perspective, why did the legislature remove the language repealing 940-04 in 85?
So a few points on that. I think, you know, the first thing we have to keep in mind is that we only get to legislative history if the question of whether there's a conflict between these statutes isn't answered from the text. And so we have to start with the text. And the text of the statute, if 940-04 sub 1 applies to abortion, we have both types of implied repeal. So I'll come back to that. But in terms of if we were to get to the legislative history, I think the key point is that the legislature contemplated putting language in that would have said this statute, meaning 940-15 in 1985 when it was enacted, cannot be ever viewed as repealing 940-04, and it didn't include that language. And so if we get to that point, I think it is relevant, it would become relevant because the legislature was obviously aware that these statutes conflicted.
Okay, certainly now.
Thank you.
Putting the cart before the horse, sorry about that.
Oh, no, absolutely no problem. So Wisconsin courts recognize two forms of implied repeal, and both are present here. First, later statute has impliedly repealed an earlier one when the two directly conflict, when they irreconcilably conflict. When we look at the mid-1800s ban listed in 940.04 sub 1 versus 940.15, which we've just been discussing, both are statutes titled abortion. Both speak to when it is and is not a crime in Wisconsin to provide an abortion, both as to the stage of the pregnancy and the pregnant woman's condition. And they say directly contradictory things on both counts. It is impossible for physicians to comply with providing abortions not necessary to save the life of the pregnant woman under 940.15 without violating 940.04 sub 1 if it applies to abortion. Nor is it any response whatsoever for District Attorney Urmanski to say that there is no conflict between those statutes because no statute creates a quote-unquote right to abortion. That argument misunderstands criminal laws at a foundational level. Criminal law does not start by telling us what is lawful. It tells us what is illegal and then puts the boundaries on the prohibition through the scope of the statute and its exception. And so just to illustrate the conflict between these laws, let's imagine Wisconsin has two hypothetical criminal laws. The first says it is illegal for pedestrians to cross the street unless the walk sign is illuminated. The second says it is illegal for pedestrians to cross the street under any circumstances unless necessary to save the life of another pedestrian. Those two laws cannot both be the law of Wisconsin at the same time. They can't be because one tells us circumstances when it is lawful for pedestrians to cross the street, i.e. when the walk sign is illuminated, and the other makes those same factual circumstances a crime. But that's the conflict that exists between these statutes if both applies to abortion. And that conflict is unavoidable for 940.15 to have meaning. So if, for example, a woman suffers a medical emergency when pregnant and her physician concludes that if her pregnancy is not terminated, she will suffer from a severe disability for the rest of her life, 940.15 tells a physician it is lawful to provide that woman with an abortion, but 940.04 says it would be a felony. If a woman is sexually assaulted and 4 weeks later she learns she's pregnant as a result of the assault and wishes to obtain an abortion, 940.15 tells physicians it is lawful to provide her with that abortion, but 940.04 would say it's a felony. And that direct conflict is just fundamentally different from Granberry, where District Attorney Urmanski wrongly tries to place a lot of the weight of his argument. And here's why. Let's return to the pedestrian hypothetical. This is Granberry. Law 1 says it is unlawful for pedestrians to cross the street unless the walk sign is illuminated. Law 2 says it is unlawful for pedestrians to cross the street while walking a dog unless the dog is on a leash. Those statutes serve distinct purposes. And if a pedestrian is walking across the street with a dog, the pedestrian has to comply with both. And it would be unreasonable for a pedestrian who's walking across the street with a dog to say, well, because my dog is on the leash, it doesn't matter whether the walk sign is illuminated. That's the argument that the Supreme Court rejected in Granberry, and that's fundamentally different than the case here. And that all is just the conflict between 940.04 sub 1 and 940.15. But we have another type of implied repeal in Wisconsin, and that occurs when there's a later enacted series of laws that regulate and so occupy a field governing the who, what, where, when, why, how, so as to have supplanted the earlier law to the contrary. That the best that District Attorney Urmanski can offer this court is to say that, to try to harmonize these statutes, is to say that 940.04 sub 1 should swallow every single one of Wisconsin's many, many statutes regulating physicians providing lawful abortion. Every one of them, that it should render every one of them meaningless, shows exactly the conflict and why he can't succeed on his motion to dismiss.
I'm just going to turn to Attorney Freehill to see if you have anything to add, and then I will certainly let you
Thank you, Your Honor. I don't want to repeat what plaintiff's counsel so capably covered on the implied repeal argument. I will add, too, that I think something that's getting short shrift here as far as conflict is that there's a life-saving exception in both 940.04 and 940.15. In 940.15, that is that if post-viability life-saving abortion needs to be performed, it needs to be in a hospital on an inpatient basis. In 940.04, sub 5, that life-saving abortion has to be performed in a licensed maternity hospital. And as we explained thoroughly in our brief, that is something that does not exist anymore. And it did at the time that that law was passed. There was a certain license for a certain category of hospital that was deemed a maternity hospital. That has disappeared. And when the legislature passed later laws, they passed them with the full knowledge that that exception, that part of 940.04 is essentially inoperable. So there is an inherent conflict, is my point, between 940.15 and 940.04. You know, DA Urmansky wants to kind of skip over that or say, well, don't take it so technically. It's probably, you know, what qualifies today. But we have to read the statute for what it says. And a physician, like my clients, an emergency room physician, a maternal fetal health specialist, an OB-GYN, they don't know what law is operable, and if they look at these and take them on face value, as DA Urmansky would want them to interpret that 940.04 controls, then they can't perform a life-saving abortion because they can't get to a licensed maternity hospital because that doesn't exist. So you know, again, it's a point that I think is getting overlooked a little bit here, but I think is very important in this implied repeal and conflict scenario too. But we certainly, our position is that the second type of implied repeal scenario where a later statute or a whole group of statutes like we have here have been passed more recently and they occupy this whole field, they clearly are a substitute for the 19th century law when they answer all of the questions that a physician would have about who, when, where, why, how an abortion can be performed, then certainly they are plainly intended as a substitute for this 19th century law.
So with the conflict with the maternity hospital, is your position then that conflict would serve as an implied repeal for the entire 940 statute or just Section 5?
Well, I think that if it didn't serve as a conflict for the whole, then the result would be absolutely absurd and something that even DA Urmansky hasn't argued, that there would be no abortion under any circumstances.
Thank you. Attorney Tome.
Thank you, Your Honor. I guess in response to the last question, I think, you know, we've put this in the brief. I mean, to the extent the court finds any conflict, an implied repeal is limited to the extent of the conflict. So, for example, if the court believes that, you know, subsequent legislation saying abortions have to be performed in a particular type of facility has operated as an implied repeal of the reference to a licensed maternity hospital in 940.04 sub 1, I think any repeal would just be limited to that. You would essentially say, okay, now this exception is, you know, you can perform an abortion if it's necessary or determined by two other physicians to be necessary to save the life of the mother, so long as that abortion is performed in whatever the facility the law currently says an abortion needs to be performed in. So it wouldn't deal with, I think, the broader, quote, ban. So that's the first point I would make there. I think, let's get back to first principles, though. You know, we're here today because ultimately the plaintiffs and the interveners are asking the judiciary to do something that our policymaking branches not only haven't done, but they've expressly decided not to do. There was language expressly repealing 940.04 when 940.15 was before the legislature, and they took it out. You know, we've cited State versus Gonnelly that essentially says when that happens, it's not the court's job to do what the legislature has said it's not going to do. But beyond that, you know, claiming an implied repeal is a disfavored argument for obvious reasons. There are significant separation of powers implications when a court says, you know, I have a duty to enforce the laws as written, but in this case, I'm going to say this law is no longer on the books, even though the legislature hasn't said anything about it. You know, for that reason, there's a strong public policy favoring the continued validity of a statute, except where it has been expressly repealed, and the plaintiffs and the interveners bear a very high burden of demonstrating that an implied repeal has occurred. And, you know, I guess on this point, I'd like to pause and reflect on, you know, sort of some of the back and forth that's played out in the courtroom today. You know, we say it's a 1955 statute because 940-04 was enacted in 1955 by our legislature. We've heard over and over and over again about how this is a mid-1800s ban because it is true. There are predecessor statutes going back to the founding of this state addressing this issue, and the case law is there. When you're talking about a long-standing type prohibition, the burden on implied repeal is actually even higher for the plaintiff. So I think from that perspective, the burden gets higher. You know, we've heard that, well, yes, they took out the express repeal language, but they also took out language that said, you know, this statute will not operate as an implied repeal. You know, I'm not sure what that says about the legislature's intent, but the fact of the matter here is a tie goes to the continuing validity of the statute. They have to show either that the statutes are irreconcilable or that there is a clear legislative intent that subsequent statutes have, you know, operated as substitutes for 940-04. So let's talk about, you know, impossibility. And
Let me just, if I could interrupt.
Yeah.
So assuming 940-04 sub 1 applies to abortion, and assuming that all of these subsequent statutes somehow governing abortion, including, you know, sections 48.375, 253s, 940.15, how much further would the legislature have to go to create the kind of regime that would impliedly repeal the statute?
is your question, what is lacking here is essentially what I'm hearing you say.
Where's
It's
the
like,
line? What would we need?
yeah, so I think what we would need is a situation where that regime on which the plaintiffs are relying doesn't include language that says this statute shall not operate to recognize a right to an abortion or to treat as lawful an abortion that would otherwise be unlawful. And it says that in 3 of those statutes, 3 of the primary ones on which they rely. The legislature went out of its way to say not only this shall not be construed to recognize a right to abortion, but it shall not be construed to recognize as lawful an abortion that is otherwise unlawful. And when they argue that these statutes step in to repeal a ban on abortion, that is exactly what they're saying. They are exactly saying that these statutes are operating to make lawful abortions that would otherwise be unlawful under 940-04. Now, the response, which is in their briefs, has been, well, that language was put in when these statutes were passed after Roe, and what the legislature was really talking about was what was lawful at the time. The legislature didn't say that. And actually, if you look at the Arizona Court of Appeals case that they have cited, you know, that's still working its way through the courts. I know there's a petition for review with the Arizona Supreme Court. There was similar language in the Arizona law, but it actually said this shall not operate to make lawful an abortion that is otherwise currently unlawful. And if you look at what the Court of Appeals there, they said, well, it said currently unlawful, and when this statute was passed, or, you know, that type of an abortion wasn't currently unlawful. It was recognized by Roe. Our legislature didn't do that. Our legislature used broader language, and it said, can't do it. You can't take this statute to make lawful something that is otherwise unlawful. And the fact of the matter is, it is well established that when you have a statute like 940-04, which has been declared unconstitutional, it stays on the books. And when the when the case that ruled that statute unconstitutional is overturned, the statute goes right back into operative effect. We cited a Justice Abrahamson concurrence to that effect in Wisconsin law, and we've cited case law from around the country to that effect. And, you know, I don't even really think that point is particularly contested. So, you know, I think 3 of the primary statutes on which the plaintiffs and interveners relied have that type of savings language. I would also point out that 253.10, which is the informed consent statute on which they rely, actually has language at the sort of the legislative intent and findings section in the beginning of the statute that talks about how it's the legislature's intent to protect the life of the unborn child to the extent constitutionally permissible. So if the legislature is saying our intent is to protect unborn children to the constitutional line, to the extent it's constitutionally permissible, I don't know how it's fair to say that they actually have had this intent to repeal a statute that would actually be constitutional under current law. There's the 20-week ban that also had similar savings language. I mean, I think that's just a partially overlapping prohibition, which are common in criminal law, I think, as Your Honor's probably well aware. There's the ban on abortion-inducing drugs. Also has savings language, but also there's no inconsistency there. I would imagine you could induce a medically necessary abortion under 940-04 using drugs. I mean, I don't think it's fair to say that, a particular statute regulating the way an abortion is supposed to be performed using drugs as opposed to some other mechanism is a clear legislative intent that we're going to, repeal a statute that actually does allow for abortions in some circumstances. I don't know how that gets you there. There's the partial birth abortion ban. Again, it's not an inconsistent provision. And in fact, I would say that would be our, one of our rejoinders to the Attorney General's argument, which, as I read it in the briefs, was essentially to the effect of, well, if something's not covered by a statute, that's a sign to you that it's legal. That's not true. If you have a partial birth abortion ban, it's not commenting on anything else. It's not a signal to people that every other form of abortion is legal. The hypothetical about it is illegal to cross the street and then it is illegal to cross the street unless, that's not actually what 940-15 says. 940-15 has a ban on post-viability abortions, and then it says this particular ban is not going to apply under these particular circumstances. It is not saying that any other abortion is legal. It is not saying that people have a right to an abortion. It is just saying these are the circumstances under which this particular ban applies. And it creates a separate criminal statute that has distinct elements and distinct penalties. And under the criminal law, it is very clear that you can have multiple partially overlapping, even completely overlapping criminal statutes. You can have a statute that treats the exact same conduct as a felony and a misdemeanor, and prosecutors get the discretion as to what they're going to charge. And I think that's kind of the rejoinder to some of these arguments that what District Attorney Hermansky is arguing is going to wipe these statutes off the book. That's not true at all. You can have 940-15, you can have the 20-week ban, you can have the partial birth abortion ban. They're all separate criminal statutes with their own elements, their own penalties. Wisconsin state law is very clear. It is very clear. There's a statute that sets this out, that when you have more than one crime that can be charged, the prosecutor gets discretion as to what they want to charge. It's actually, I think, pretty basic. Some of the other statutes on which they've relied, 253-095 requires admitting privileges. I think, I'm going off the top of my head, within 30 miles to perform an abortion. I don't see how that demonstrates a clear legislative intent to remove from the books a ban on abortions that does allow for abortions in some circumstances. You can read that in harmony. It's essentially saying if you're going to perform an abortion that is allowed by 940-04, you have to meet this requirement. And I believe there's 48.375, which deals with parental consent for minors. I don't see how a law requiring parental consent for medical procedure for minors requires, or it creates a clear legislative intent to repeal an otherwise applicable ban. And I think any inconsistency there would probably be limited to the minor context. And then lastly, you've got a ban on government funding of abortions. I don't think that, again, we've got to talk about the burden here, Your Honor. Absent a conflict, we're talking about there has to be a clear legislative intent that can be divined from the otherwise applicable statutory framework to remove from the books not only a law that was passed by the legislature, but a law that the legislature expressly considered repealing and chose not to do so. And, I think a couple of additional points on that. I know right now there is a bill pending to expressly repeal 940-04. I know multiple bills in the last 20 years have been introduced to repeal 940-04. what is at issue here ultimately is a request to Your Honor, to the judiciary, to do something that our policymakers aren't doing. And it may be that the citizens of the state of Wisconsin would be better served by a different statute, but that is not a decision for this court or these parties to make. It's a decision for our policymakers. And I think on legislative intent, I did want to point out a couple of other things, and that's in the pleadings that were filed, the Attorney General's response to the motion to dismiss, they included some legislative history materials, and I just want to make sure this is clarified for the court. In their appendix, which is document 99, they have an appendix 101 to 104. This is not a document that's in any kind of order. The last page, Plaintiff's Appendix 104, that is actually an excerpt from the beginning of the original bill in 1985. That is not from the legislation that was ultimately enacted by the legislature in 1985. And in fact, if you look at the legislative history, and this is not currently in the record, I think it's subject to judicial notice, we'll submit it to the court. If you look at the legislative history for the substitute amendment that was passed, that replaced that original bill, you have two memos, October 16th, 1985, one from the Legislative Council staff, one from the Legislative Fiscal Bureau. I'm just going to read from the Legislative Fiscal Bureau's memo. The substitute maintains other provisions of current law relating to abortion. Assembly Bill 510, which was the original bill, repeals the current law entirely. The legislature knew exactly what it was doing. Now, I will be upfront about the fact that here they are talking about the substitute amendment that had that no implied repeal language in it, which was subsequently taken out. But the fact of the matter is, that's not what ultimately matters. The tie does not go to the plaintiff seeking an implied repeal here. And you'll also see in the legislative history, to the extent you go through all of it, there was a subsequent amendment offered by a senator that would have expressly repealed the bill. It was withdrawn. I think everybody was attuned to this issue at the time, and they chose not to repeal the law. And I think it is a grave thing for a court under these circumstances to say, regardless of how we feel about the law, regardless of how we feel about the policy implemented by the law, that when the legislature was aware of this issue, expressly decided not to repeal the law, that law was in fact repealed and is no longer on the books.
Thank you. You heard Counsel for District Attorney Urmanski say a number of times that tie goes to the law. Here's why that's incorrect, because the Wisconsin Supreme Court has expressly said that when we are talking about lack of clarity in the law as to what is and is not subject to criminal sanctions, any disfavoring or hesitation that courts have about concluding that a later law or later laws have impliedly repealed an earlier one must fall to strict construction, because the people need to be able to know before they act what is and is not subject to criminal sanction. And so I think that's just overlooking and minimizing what the entire focus of implied repeal is about when it comes to particularly conflict in criminal law. It cannot be that Wisconsin law tells the Wisconsin public that the same factual acts are both lawful and illegal at the same time. As to the construction language in some of the provisions in Chapter 253, I think most notably that's nowhere to be found in 940.15, but moreover, that language is not in any way creating some sort of trigger law, which I think really is what District Urmanski is trying to argue. That language can't, in the statutes where it's found, be reasonably read to be understood as applying as it relates to 940.04, because one, 940.04.1 was not enforceable at the time any of those laws were enacted, but moreover, none of those statutes have meaning if the only circumstance in which an abortion can be provided in the state of Wisconsin is when it's necessary to save the life of the pregnant woman. And so to say, to go through the list, I mean, when you look at, for example, 25310, voluntary and informed consent, a 24-hour waiting period, a requirement of showing an ultrasound, that has absolutely no meaning if the only circumstance in which an abortion is being provided is to save the pregnant woman's life. 253-107, the restriction on later term abortion to 20 weeks, absent a medical emergency. No purpose if the only circumstance where an abortion can be provided is when necessary to save the pregnant woman's life. As to the medication abortion provision that District Attorney Hermansky tried to argue is not in conflict, when you look at 253-105, it says that the physician has to be present in the room when the medication abortion is handed to the pregnant woman. That makes absolutely no sense if the only circumstance in when an abortion could be provided is when it's absolutely necessary to save the woman's life, and we can go on and on that. And one of the other points that I heard was that in sort of responding to our arguments, well, there are all these other, look at the partial birth abortion ban in 940-16, there are all these other laws, and so therefore that somehow means that 940-15 doesn't cover the entire subject of abortion. Really, I think you can look at the titles. 940-04 and 940-15 are both titled abortion. You can look at the text. 940-04 and 940-15. 940-15 sits exactly in the spot that 940-04 sat. It says, it covers when it is and is not a crime to provide an abortion both as to stage of pregnancy and condition of the pregnant woman. Sub 5 of 940-15 says it is illegal for anyone other than a physician to provide abortion in Wisconsin. Full stop. No restriction as to when we're talking about. And so then when you consider that statute, and you look at the many other regulatory statutes, those are targeted statutes that deal with and impose specific additional requirements for physicians providing lawful abortion. Those statutes are not covering the entire subject on their own, but that's not the standard. The question is, has the state of Wisconsin enacted a regulatory scheme that tells physicians, here are the circumstances under which it is lawful to provide abortion? And the answer has to be yes. And that's what, when we look at cases like the Weeks case, which is a federal case that we cite, the McCorvey case, a Fifth Circuit case, both of those dealing with the conflict in abortion laws. To go to Weeks, the court said, it is clearly inconsistent to provide in one statute that abortions are permissible if set guidelines are followed, and in another to provide that they're criminally prohibited. In McCorvey, the regulatory provisions can't be harmonized with laws that purport to criminalize abortion because and this is what the court stressed in McCorvey, and I think it's equally true under Wisconsin laws, these are not meant, you don't look at every single one of Wisconsin's modern abortion laws and you can't read those as simply an addendum onto a near total ban. That makes absolutely no sense. And just one last point on the construction language in some of those provisions of Chapter 253. The court in Weeks, and I think this is a really important point, stressed that, look, the legislature can't avoid conflict in the world of laws like this by just simply saying, we would really hope that this doesn't create a massive conflict. That's not what the court has to be concerned with. The question is there a consistent body of law which people can use to guide their behavior? Can people, specifically here physicians in the state of Wisconsin, know what is and is not illegal based on the text of Wisconsin statutes before they act? And they can't if 940-04 applies to abortion.
Just as a clarifying, because I think it was in your brief a couple of places, but as far as the strict construction, I mean, you're primarily relying on state versus Christensen, correct?
Yes.
And I mean, It seems a little distinguished, doesn't it? I mean, the fact that, the language you pulled from it, but in that there was the statute cited to basically another statute which had been repealed. So, I mean, it's pulling a lot of very strong language from a very specific case that, to me, is pretty easily distinguished between what we have here.
So I think that, well, one, I would say, and I don't want to make interveners' argument for them, but I think that's sort of akin to what they're arguing as to the licensed maternity hospital in the absence of any definition on that. But I think even beyond that, the court's right that that's a distinguishing fact difference between the cases, but the principle is the same, because what that is saying is that when an individual physician's Wisconsin public looks at the laws of the state of Wisconsin, are those laws clear on when it is and is not a crime to perform an abortion in the state of Wisconsin? And if the answer is no, what I think Christensen is really emphasizing is that any apprehension that courts might otherwise have of saying that a law has been impliedly repealed has to come second to the foundational requirement that our laws set forth what is and is not lawful. I mean, that's the very foundation of the rule of law, is that the people need to be able to know what conduct is and is not prohibited before they act. And so I agree that I think that is a factual distinction, but the principle applies equally here, and I would say even more forcefully because of the strength of the direct conflict and then the entire world of regulation of lawful abortion.
And I'm sure Attorney Tone would be making this argument to some extent, but based on that, I mean, in Christensen, it was almost an impossibility to comply with the statute as it was written, whereas here, I'm guessing D.A. Urmansky would say it's not an impossibility. If you don't perform abortions, there's no problem.
Yep.
Except for that carved out exception. I do not mean to,
Yeah, so here's why that can't be right. You cannot harmonize irreconcilable statutes by saying the earlier just renders the latter completely meaningless. The question when we're talking about conflict from the case law is, can both statutes be simultaneously read to have effect? And what the courts have said, and I think you could see this most easily in the commitment of Matthew A.B. case that we cite in the brief, is that the answer cannot be to harmonize statutes that one would render all of the rest meaningless, because then you're not saying that both statutes can be read as having an effect. Instead, you're saying that none of these would have any effect. And so what we know is that when you have a tension between two laws or two sets of laws where both cannot be read as simultaneously having effect, that's the irreconcilability, then the earlier one has to fall because the legislature enacted the later ones later.
Attorney Tone.
Thank you, Your Honor. I guess briefly on that last point, I made this point earlier. I'll make it again. 940.15 still has effect. It's a separate criminal prohibition. This is the type of argument you would see a criminal defendant make where they would say, oh, there's this statute that makes this a misdemeanor. You can't charge me with this other statute that makes it a felony. If you do that, you're going to render this meaningless. That's not true. They're two separate criminal prohibitions with separate punishments and separate elements. A prosecutor can exercise their discretion as to which one to charge. So, for example, if you had an act that violated 940.15 and 940.041, a prosecutor could choose to charge under 940.041, 940.15, or both under state law.
So then we're back to doctors should choose their counties carefully?
Well, I do think there's an element of prosecutorial discretion here, Your Honor, and I think the Supreme Court has been very clear, and, you know, this is the
But your
full...
argument is sort of like, it's clear, you can, you know, and that doesn't seem real clear.
But that's, Your Honor, that's prosecutorial discretion. I mean, there's a whole line of cases talking about how the bounds of prosecutorial discretion are essentially set by, you know, not taking into account improper factors in your charging decisions.
And I guess I'm not talking about this from the prosecutor perspective, but from the people of Wisconsin having a right to know what law applies where.
And I think it sounds flippant, and I don't intend it to be because I'm quoting our Supreme Court, but the response is what our state Supreme Court wrote in State versus Granberry. The solution is elegant in its simplicity. Read 940.04 sub 1. If it's on the books and it's there, and, you know, I don't think...
It's a little circular, because now you're basically saying 940.15 doesn't do anything then, right? So go back to 940.
That's not... I apologize, didn't mean to interrupt you there, Your Honor. No, I don't think that's what I'm saying. I think what I'm saying is 940.15 is there as a separate prohibition that a prosecutor could choose to charge. I mean, you see cases, for example, I believe it's... the name's escaping me now. It's not cited in the briefs, but it's milk fraud. You see these milk fraud cases where, you know, somebody mislabels milk that they sell or something like that, or they don't use the right information in the testing, and it's a misdemeanor under state law. And then they get charged with the felony theft of services. And they say, well, no, I should be charged with the misdemeanor, not the felony theft of services. And our courts have been very clear. No, you can charge them with felony theft of services. Prosecutor has discretion, and both laws apply. So I think that would be the response on that particular point. I think one thing the Attorney General's office is doing is it's sort of like mixing rule of lenity and implied repeal, I think, in a way that doesn't necessarily track for me. I think, Your Honor, you've already emphasized the factual distinctions between this case and Christensen. I think one point on which, you know, I might agree with the Attorney General's office is, you know, you might have a lenity problem, for example, if a physician was charged for performing a life-saving abortion someplace that wasn't a licensed maternity hospital. I think that would be potentially the exact Christensen problem, right? Because in that case, you were referring to, you know, there was a reference in the statute to something that no longer existed in the sense of like that had been removed from the statute. So here, if I understand the interveners correctly, they're saying, well, licensed maternity hospitals no longer exist. The statutes that regulated licensed maternity hospitals are no longer on the books. How can you charge somebody for not doing something in a licensed maternity hospital? And I think my answer to that would be, you know, twofold. I think one, what were considered to be licensed maternity hospitals at the time, those types of facilities still exist. But two, that's an argument to me raised if in fact anybody is ever charged with performing a life-saving abortion in some place that does not, for not performing a life-saving abortion in a licensed maternity hospital. That is not a reason to strike this entire statute off the books. Yeah, I think I'll leave it at that.
Okay. I will come back to you. I don't have any specific other questions, but I'm happy to hear a few more minutes, and I want to give you an opportunity also, Attorney Juris, you look like you want to respond to that, but so, yeah, okay, and so then, let's see, Attorney Freehill.
I have a few points, and I'll try to make it brief.
No,
but a few really important things that I heard is that the safest thing here is to just, the alternative that Urmansky has presented is just don't provide abortions, and then you avoid this whole gray area and all of these concerns about what the law is or isn't. I want to make very clear that my clients are practicing physicians. They don't provide, you know, elective abortions. That's not what we're talking about. They're providing care for women in high-risk scenarios. They're providing care for women who walk into the emergency room door. And these physicians need to know, not just these three physicians, but every physician across the state and every county. They need to know what they can do because they make these decisions not within days or not within hours or within minutes, but within seconds. They have to know what the law allows them to do. And we're here today on a motion to dismiss. where Urmanski is arguing that the law is so clear that the physicians cannot even ask this court to answer the question of what the law is. And I don't want the point to be lost that attorneys, district attorneys, legal scholars poring over this for months can't make sense of it. If the court were to dismiss this, we would be asking physicians to continue to make these split-second decisions and give them no answer because the law doesn't require us to. And I think that is an absolutely untenable position. It has been almost a year now of physicians operating in this environment without an answer. So I think that to say that, well, this is a decision for the legislature and they've proposed things in the past and they continue to, and there are things that they could pass. The point is that they haven't. And in the meantime, patients in Wisconsin can't count on getting the care that they need when they need it. They can't trust that they will. And physicians can't trust that they're not going to end up behind bars for doing what they've been trained to do. I think I'll leave it at that.
Okay.
Thank you. Just my last point on this. The case law and District Attorney Urmanski's discussion all concern situations where the same factual act may be unlawful under multiple statutes or may be subject to different punishments under different statutes. That's not what we're talking about here. This is not a situation of, do physicians in Wisconsin have, where physicians in Wisconsin would have notice that they could be charged under one of many different statutes. The problem here is that physicians in Wisconsin and the Wisconsin public needs to look at the law to know what is and is not illegal. And so there cannot be a scenario, and that's exactly what is currently happening, where physicians in Wisconsin look at Wisconsin law, and one Wisconsin law from the mid-1800s would say illegal, and other Wisconsin law to that exact same factual circumstance says legal. That cannot be, and I'll leave it at that.
And final words, Attorney Tone?
Yeah, just briefly, I mean, that is essentially the argument the defendant made in Granberry. I mean, the defendant in Granberry said, what I'm doing complies with the law. How can I be prosecuted? And our Supreme Court's response was, well, just because you're complying with the safe transport law by putting your handgun in, your dashboard thing, doesn't mean we can't prosecute you for not having a concealed carry permit. And so I think this notion that what we're talking about here are just laws where the same conduct is prohibited, that's not true. You can have partially overlapping criminal prohibitions where one crime, I mean, almost the entire essence of criminal law is that a crime exists. There are separate criminal prohibitions for separate acts, right? You can't just say, well, here's this one criminal prohibition that applies and everything else is legal. There's obviously an entire statute book. And again, I think 940.04 itself is clear, and our Supreme Court has said, read the statute. What you cannot do, at least if we're talking about void for vagueness, which I think we've sort of bleeded into that a little bit, is, say, well, it's vague because there's all these other statutes out there. That's not what our Supreme Court did in Granberry. They said, no, you have to look at the law under which you're being charged. You have to read the law under which you're being charged, and then you have to make that vagueness assessment. And I don't know if Your Honor intended to have questions on that particular issue or the destitute issue. I think the briefs are pretty clear on this. The interveners have made the point about their clients being doctors who are providing care. But the fact of the matter is they've brought a facial challenge seeking to say this law is not applicable to abortions across the board, regardless of their individual circumstances. Frankly, I don't think there's allegations in the complaint that would support a justiciable controversy with respect to an as-applied challenge. We don't have any allegations as to the particular circumstances in which they're performing abortions or would be called upon to perform abortions. They're asking for a facial invalidation of the statute as applied across the board to both elective abortions and in their circumstance. I think it's very clear that, if there is a clear-cut core of conduct that falls within the prohibition, it's not void for vagueness. We set this out in our briefs. I think here that is the case. I think we can all agree that is the case, that there is a clear-cut core of conduct, elective abortions on healthy mothers, that would be banned by this particular ban. So on the void for vagueness argument, I think that's all I would say. We deal with the quick issue in the briefs. It's not applicable here. And then lastly, desuetude. There's no basis for applying that doctrine under Wisconsin law. One state does it. Most states recognize it's antithetical to democratic government. I think, here, especially in a situation where any lack of enforcement was the product of a United States Supreme Court decision. And look, I get it. There was a United States Supreme Court decision from 1972 or 1973, that prohibited the enforcement of these statutes. But the law is also clear that when that decision goes away, the statutes are then enforceable. And I don't think we here can sit here and say that a societal consensus has built up on the issue of abortion. It is the most hotly contested political issue of our time. And to say that, there's a societal consensus that a law that is on the books can no longer be enforced, even though it's on the books through a doctrine that only one state in the United States has adopted, is a pretty big reach from my perspective, and I don't think there's any basis for that argument.
I have no further questions. I had only envisioned an hour and a half for this. I don't know if, since Attorney Tome went into a little bit on the desuetude and vague for if the parties want to go there, rely on their briefs, I can certainly extend it a little bit. But it was sort of a cursory argument based on his brief, so I don't know if there's anything further that Attorney Juris looks like there's something.
Just two very brief points, and that'll be it from me. As to the desuetude theory, I think one thing that I just want to stress is that District Attorney Urmanski relies on case law that simply stands for the proposition that a court declaring a law unconstitutional does not erase it from the statute books, right? And so if, for example, a lower court holds that a statute is unconstitutional and then a higher court reverses that on appeal, it's not as if the statute has been deleted from the books based on the lower court's holding such that the legislature would have to repass that. None of that case law concerns the unprecedented combination of circumstances here, and frankly, the fact that such a claim would be unprecedented in Wisconsin law is unsurprising, given that this combination of circumstances and the Supreme Court's decision in Dobbs is unprecedented in American history. And then really the last point I just wanted to make is one of procedure. We're of course asking this court to deny District Attorney Urmanski's motion to dismiss. And just to be clear, should this court do so, as we hope it will, our plan at that point, following that order from the court and District Attorney Urmanski's answer, would be to move for judgment on the pleadings under 802.06 sub 3 on our first claim, that's the implied repeal or alternatively State v. Black argument. And we would hope to seek expedited briefing before this court on that motion, where then all parties would be able to be heard. That can be decided on the law and potentially appealed under 813.025 sub 3. We're confident that that will decide the case in its entirety, but if somehow it did not, our desuetude claim, which does involve facts, could be addressed on a remand to the circuit court through discovery and summary judgment limited to that claim. Ultimately, our goal is to litigate this case in as efficient as a way as possible, given the significance and importance of this issue and obtaining clarity on it for the people of Wisconsin. Thank you.
Thank you. Anything further, Attorney Hill?
I think briefly on the desuetude issue, I think obviously you saw this play out in the United States Supreme Court's own decisions as to whether or not this is in fact unprecedented in United States history. I think the majority would say it isn't. The dissent said it was. But I think ultimately, in terms of the application of desuetude, it doesn't matter. That the doctrine doesn't apply here. And to apply it here would be inconsistent with every statement from the Wisconsin Supreme Court throughout its history that courts have to apply statutes as they're written.
All right, thank you. I will take this all under advisement. I appreciate the very well-reasoned briefs and arguments, and I make no promises, but I understand the importance of the timeliness of this. So with that, we will be adjourned. Thank you.
Thank you.
Thank you.
Your Honor.